So this update was originally going to be released on Monday evening when I got the message that my Audible narration had finally become available. There were a lot of delays with this. The audiobook is finally available on Audible, so if you use Audible, please be sure to check that out. And if you've purchased the book in any of its formats, please don't forget to leave them a review. In a surprising update, the trial is almost over. It began yesterday with jury selection, and all witness testimony completed today. Alex had already defaulted, and the judge had decided back in June that there weren't sufficient grounds to continue the suit with Chad Westendorf or Palmetto State Bank. That left only Cory and Cory's law firm. Cory took the stand today and continues to insist that he knew nothing of the fraud beforehand, that he trusted Alex, that he had no idea what Alex intended to do, and that he thought Alex was doing everything he could to get the most money for the Satterfield boys. Sifting through this mountain of evidence, I can't imagine a jury finding that to be so. The problem is, when a lot of the evidence gets ruled out, the jury doesn't get to see it. And so I'm not sure what all they were able to be told in the end. The judge had suggested to Nautilus that the 2 causes of action based on breach be removed, but they insisted on keeping those in, which could have been a mistake because it left Judge Gergel to take matters in his hand and remove those 2 causes of action. The thing about that move is that it very well could signal to the jury that the judge himself doesn't see Cory as culpable. And you'll see in the second half of this update today that the judge had already ruled to bifurcate, which is to split this trial into 2 sections, because the paperwork for arranging the verdicts was so very complicated. It could be a case of absolute overwhelm, but when I look at the literal thousands and thousands of pages that I have printed out from this case, I cannot imagine everything having finished in 1 day's time. But that's where we are. So tomorrow we'll be closing arguments and the jury will already begin deliberating on the verdict. This whole case could be wrapped up by tomorrow. And I wouldn't think twice about that if it had been a longer trial where we could be assured that the jury had gotten a full story. But in a case with so many details that gets rushed through in 1 day, it doesn't give the jury much time to familiarize with the people, with the story, or even to meditate about what happened, like you get to in a much longer trial. When deciding something like this, you need time to ruminate. And the financial aspects are a little complicated. The causes of action are very complicated. And there are so many. When you're introduced in a jury charge of what to look for each of these causes of action, but you only have a day's worth of testimony, that would be a little bit difficult to do. Now we're going to go ahead with the consideration of the last several documents, and there were so many that I've divided it into 2 parts. So this will just be part 1 and the rest will continue later. I had already prepared this, and then I heard the news, so I wanted to add this to the beginning just to keep you updated in real time how the case is going.
Fleming says he has no idea the reason for the claim was made up. Specifically, Nautilus is accusing Fleming of civil conspiracy, negligence, unfair trade practices, breach of duty, and breach of contract. Now, before this trial started, the judge warned the Nautilus insurance company to drop those 2 breach charges, saying there isn't a great case for them. But the insurance company argued with them anyway. Halfway through this case in the past 2 days, the judge decided to give a directed verdict on those 2 breach charges. Basically, that means the judge will tell the jury they must not find Fleming liable for breach of duty and breach of contract. From the beginning, the judge said those accusations were tag-along and overkill for Fleming. The judge says the evidence has proved Fleming did not breach any duties or any contract, but it does show questionable decisions regarding conspiracy, negligence, and business practices in this insurance claim case. Now, Alec Murdaugh has already been ordered by the same judge to pay $14.8 million in damages for his role in this case. Fleming is someone who's pleaded guilty to financial crimes at the state and federal level before, but he maintains he is innocent in this specific situation. A jury is going to hear the closing arguments tomorrow. In downtown Charleston, Melissa Rademacher, Live 5 News.
And now back to the regular episode. We left off in the last update with document 284, so we're picking up today with 285. And as you can see, there's a new mountain of filings in these last few days before trial. If you missed the last update, you'll probably need to review that to understand this one fully, because there are some document types that I won't be explaining that I explained last time, so you can find those there, and I'll link that in comments. Document 285 we won't look into. It's Nautilus's final exhibit list. The only thing I do want to point out about this document is that the fourth column here, you see it's called Bates, or docket number. And this made me recall in the conspiracy case because I have an update on the related case involving the private investigator that was hired by Parker's law team, and so that was kind of on my mind and reminded me of that. But in that case, there's a mountain of discovery. And Parker was claiming privilege on documents that actually didn't qualify as privileged and demanding certain documents be returned, and one of the issues was that they did not provide the beach team with these Bates labels. And I described them at the time, but I didn't show you an example, so this here is what that means. And if you glance down through this column, each exhibit has been given an alphanumeric label so that it can be easily tracked. These are shared amongst both sides of counsel to make it easy to call up that exhibit when needed. Without these labels, finding a document in a mountain of documents is very difficult. Even amongst my files, and I certainly don't have all of them, I make a chart for each case file and I hyperlink the list to the documents so I can pull them up with a click and don't have to waste time rummaging through them. I can't imagine what it's like to have multiple cases simultaneously, each with more discovery than the last, and have no Bates numbers to pull the files they're demanding. Anyway, that's just a quick example of what Bates numbers are and why they're so important. The next file is Nautilus's proposed voir dire. And again, if you didn't watch the last update, we talked about that, and we won't go through this whole document, but they, like the Moss and Kuhn document, are mostly interested in any connections that potential jurors may have with any person or company connected with the case. And those types of questions make up the first 9 questions, where you can see if they're connected in any way with certain attorneys or law firms, the insurance companies, the bankers, any of that. And the following questions turn to situations that may cause bias, such as a personal experience with an insurance company, working to come up with a settlement amount, knowledge of the Alex Murdaugh trial, or any familiarity with Gloria's death. These questions are all pretty typical, nothing out of the ordinary here. The next filing is an order from the court, and most of these orders are not available to the public to view, but from the responses we can see what that order was about. Document number 288, and we'll come across a couple of these. This one is from Moss and Kuhn, and these are the responses to that order. So we learn that the order is for all of the parties to deliver courtesy copies of their proposed exhibits before December 30th, 2024, and this is them letting the court know that they've complied with this order, both for themselves and for Cory. 289 is another order that's not publicly available, but it was addressed to Nautilus and Alex, and this was kind of a big point in the suit. It informs them that they must file a joint status report also by December 30th at 5 p.m., and we'll find out why in just a moment. In the last update, we went over Moss and Kuhn's motion in limine, and we spent even more time going over Cory's. That's what led to the title of that episode, Judge, Please Exclude All of the Evidence That Makes Me Look Guilty, because he really was asking for the moon. And you'll learn all about what those motions are in the previous episode. But here we have document 290, and it's Nautilus's reply to Moss and Kuhn's motion in limine. And remember, this is an attempt to exclude evidence from the trial, but it must have sound legal basis in line with the rules of evidence. And since this is a federal trial, it's the federal rules of evidence they have to comply with. So after each side presents their case about what they feel should be excluded and why, there's a chance for the other side to rebut. And that's what this is. This is Nautilus saying, you asked for these things, here's why we don't think you should get them. So one of the things that Moss and Kuhn, which is Cory's law firm, had asked to be excluded was that any testimony or reference related to the settlement of Alex's other insurance carrier, Lloyd's of London, not be admitted, stating that the evidence would be unrelated, couldn't make any fact more or less probable, that it's of no consequence and has little to no probative value. These are bold claims indeed. And so Nautilus responds by saying it's directly relevant. And they list out the reasons for 1, repetition. They say a prior act of fraud against Lloyd's that was repeated with the Nautilus shows repetition and potential for repetition. That these are directly relevant to the Unfair Trade Practices Act claim, and we'll talk a little bit more about that act in just a bit, and they bear on culpability and intent. So they are indeed relevant, they say. They also say because of connection, and the connection is that the resolution with Lloyd's is explicitly part of the agreement that was reached at mediation to resolve the claim. They also say that Moss and Kuhn themselves designate portions of Mr. Grantland's deposition where the Lloyd's resolution was discussed. So I looked those up for you. The first one, if we look at Moss and Kuhn's exhibit list, number 7, we find the mediation agreement right there. I also looked up the exhibit, and here it is with the mention of Brit Syndicates, which is a part of Lloyd's of London. So we see the date of this mediation. We see Brit Syndicates mentioned twice, signed by Cory, and it's indeed a part of Moss and Kuhn's own discovery. They also had mentioned this deposition from John Grantland, and we find this in Moss and Kuhn's deposition designation form. So because of these two things, they say they shouldn't have to exclude it. The third point was intent. They say it's directly relevant because Lloyd's had agreed to settle the claim on November 12, 2018. The very next day at 9:14 a.m., Cory directed his assistant, Tanya King, "We need to hold this till we get the PR changed." Now, if you don't remember this, I did several stories about the Gloria Satterfield theft. And one of the ways they were able to do it is that originally Gloria's son Tony had been set up as the personal representative of her estate. It's normally handled by family members. In fact, in some of the discovery I read in Russell Lafitte's lawsuit, it was actually against bank policy for members of the bank to take the position as personal representative unless it was a family member. Most of us wouldn't know that, and we would think, hey, a high-level banker is probably trustworthy. And so it was very easy for Cory and Alex to talk Tony Satterfield into signing over personal representative to Chad Westendorf at Palmetto State Bank. Why did they need him to do this? Because these settlements would be signed for. If Tony had to sign for it, he would have known that the settlement had arrived. So instead, Cory, not Alex, tells his assistant, hold off on the check. Then on December 19th, the day after Chad replaced Tony as personal representative, suddenly action is taken on this check, and this petition to approve the settlement was immediately filed in Hampton County Circuit Court. Now remember, this first settlement did go through the appropriate steps. It was signed by Judge Mullen. It was filed in the courthouse. But they're saying intent because they didn't allow Tony to see it, to sign for it, substituted him with Chad, and that was how they were able to steal the money. And they say this shows intent, which I think we all agree with. They also mention that Cory never spoke with either of the estate beneficiaries about either the payment from Lloyd's or the larger payment from Nautilus. And they have just a small section from a transcript with Cory's deposition. Did you ever have any conversations with the beneficiaries about the existence of either of the two payments by the insurance companies? And he says, I did not. So even though Tony had been removed, he was still a beneficiary along with his brother Brian, who also should have been informed, hey, your settlements come in. But that never happened. And it was Cory's responsibility as their attorney to do so. They say Cory removed Michael Satterfield, Tony's first name, as personal representative so as to conceal the payments later misappropriated by Mr. Fleming and Mr. Murdaugh. And this is directly relevant to Nautilus's claim, and also to rebut Mr. Fleming's contention that he did nothing wrong until after Nautilus agreed to settle the claim. These are Cory's movements here, no one else's but Cory's. Whether he was doing them at Alex's direction or not, he was a well-seasoned attorney and knew the way these things were supposed to go, knew that this was wrong. They mention again the Supreme Court who disbarred Cory. In their opinion, they clearly say that Cory had appropriated client funds for his own use and for Alex's benefit before. So this point is very important because of that claim that Cory is making that he did nothing wrong until after the Nautilus claim had already been paid out. If that were true, that would greatly reduce any claims against Cory. So naturally, they want this Lloyd settlement completely kept from this trial. If they could do that, they might get away with making this claim. But if it's left in, there's no way to deny that Cory had involvement long before Nautilus paid their claim. He had already directed for this settlement check not to go through until they could swap out personal representatives. So it definitely shows that Cory was involved from early on and not just after the fact. And their last point is waiver. And this is because, as they said earlier, that this deposition of Mr. Grantland that relates to the Lloyd settlement, they've designated this deposition testimony in their own exhibit list. And so they say this is directly relevant and this motion should be denied. In other words, it should not be excluded from their exhibit list to use in trial. They also filed their opposition to Cory's motion in limine for the things Cory's trying to get eliminated. So one of the main things that Cory wanted eliminated was his criminal records. Nautilus had said that Cory is stopped from denying allegations because he pleaded guilty to these crimes in his federal and state financial trials. Cory has said this is not so. He still holds that he had no knowledge of the fake forge. And he also tried to argue that his criminal convictions are irrelevant and or inadmissible. To which Nautilus says, nonsense. He is stopped from denying allegations, and that he pleaded guilty in state court to false statement or misrepresentation in the form of insurance fraud. They quote from his indictment that says that he did with an intent to injure, defraud, and deceive, knowingly make false statement or misrepresentation. Cory had used Rule 403 to argue his side. They used Rule 609 that evidence of criminal convictions may be admitted to impeach a witness. Now I put the whole 609 portion A here so that you could see they didn't just pick a small portion and exclude anything that could be used against their reasoning. But point 1 mentions crimes that are punishable by imprisonment for more than 1 year, which he definitely meets. But they specifically quote point 2 that Cory admitted by way of pleading guilty to a dishonest act and also false statements. So they say based on this rule of evidence, he should be denied this request. And the next points are so nitpicky and strange. His approach the bench request, that's the one that irked me, that every little matter needed to be whispered at the bench outside of the jury's presence where they couldn't hear it. He somehow seems to still think that he can appear innocent of these crimes if he can only keep it all away from the jury's ears. Nautilus's response is really good. They basically say a pre-trial conference will take care of all of this and will abide by whatever the court decides, but a blanket request is unnecessary, it will cause delay, and it's not in the interest of justice. Cory still appears to want to be handled very, very gently. He followed up with more hush-up stuff. He wants to make sure all the witnesses know that anything the court rules inadmissible can't be uttered in the courtroom. He doesn't want anybody to slip anything out that might make him look bad. To which their answer's also good. They kind of say, duh, if the court rules it, we'll follow it. And again, they keep saying, this applies to everyone, not just you. Now this one I'm not sure what it's about. It's just this little statement in this motion in limine without explanation. And Nautilus says there's no legal basis for this, but if the court grants it, it should apply to everyone. And it's that Nautilus be prohibited from suggesting that Cory had not called any witness to testify who is equally available to both parties. And then we have this strange request that any suggestion that Cory or his witnesses believe that any Nautilus witness is honorable or worthy of belief should be excluded. To which they say there's no basis for this request, and the credibility of witnesses is always at issue, and parties are entitled to present argument regarding the same in their respective closings. So they oppose this request, and if the court does grant it, it should apply to all parties. And the oddness continues with the next request. Cory requests exclusion of any suggestion by counsel for Nautilus as to his or her personal belief concerning the credibility of any witnesses. Again, they say he provides no legal basis for this request. The personal beliefs of all counsel are irrelevant, and all counsel should focus their argument on the parties and the evidence. And if the court is inclined to grant this request, it should apply to everyone. Number 7 shouldn't even need to be requested. It's that any contents of evidence that are not disclosed prior to the trial should be excluded, which is the normal thing, until it's been rendered to the court and counsel for Cory outside the presence of the jury. You're not supposed to bring undisclosed evidence into the court. It's all supposed to be sorted before trial, unless something suddenly becomes available in the course of the trial, like we saw with Alex's car GPS that came available right towards the end of the trial. But that's not a usual situation. Cory also wants to exclude any testimony regarding Nautilus's corporate character and good acts. Don't make them look good, is basically what he's asking. Nautilus is okay with that, except they want a distinction made that showing good character or good acts is distinctly different from evidence of an entity's policies and procedures. And so they don't want this applied to the information of what policies and procedures they have. I see what I mean? It's all just very fussy and nitpicky. He doesn't want anything good said about the other side, and he doesn't want anything bad said about himself. Another thing Cory had asked for was that he didn't want Nautilus to be able to say that claims, suits, or judgments affect insurance premium costs. He didn't want the jury sitting there thinking, this is the kind of stuff that just made my insurance bill go up. But they say he provides no legal basis for this request. And I told you we would talk a little bit more about the South Carolina unfair trade practices, and that's this part. This is one of the claims that they hold him to, that he violated the South Carolina Unfair Trade Practices Act. And there are certain elements that have to be met in order to carry out this kind of lawsuit. One of them, it can't just be that a business acted in bad faith. It also had to affect you monetarily, and it has to have an adverse effect on the public. Therefore, the idea that claims like these false kinds of claims, affected insurance premiums is relevant because that's how it affects the public. And so that's why they oppose this request. And then Cory had made a request about his file materials. I didn't understand the question at the time. Now I don't feel so bad because Nautilus themselves say, hey, we need some clarification about what he meant for this. Cory also asked that any pleading that had been amended, that no reference be made to the original. Nautilus again is like, Cory, once there's a superseding pleading, the previous one is nullified. So you basically don't need to ask this. And then here was another one that I didn't understand the first time through. Any reference as to the probable testimony of a witness who is available but not called to testify be excluded. I wondered what that was about, but it seems to point to Alex. So they say if what he's seeking to exclude are admissions made by Alex, we oppose this request. He also seeks to exclude any suggestions that the jury must extend special efforts to be fair and impartial to Nautilus. They say there's no legal basis provided for this. We oppose it. Jurors are supposed to endeavor to be fair and impartial to all parties, and that this is part of the jury charges and closing arguments. Cory again trying to exclude some evidence. Nautilus objects to this, and they say no way. They do not want their evidence restricted. And Cory also, after asking for all of these things, he ended it by saying, don't tell the jury about my motion in limine for all the things I tried to exclude. Don't let them know I'm trying to block you from telling my guilt. Nautilus simply doesn't oppose, but they ask it to apply equally to all parties and not just Cory. Cory asked that it not be said that he's denying responsibility by disputing liability and damages. They say if you keep this narrow, that's okay. But if it goes beyond things in evidence, they oppose it. He had also asked that they don't ask the jurors to put themselves in Nautilus's shoes. They say there is no legal basis for this, that this is a proper subject matter for closing arguments. And we've heard such statements made in different closing arguments before. As they tell their story, that's what they're trying to get the jury to do, to see things from their client's perspective, which basically is putting yourself in someone else's shoes. And again, he's so nervous about something being put in court that's not been pre-approved, so he asks any evidence that's not been previously addressed in the court's pretrial order be tendered outside the presence of the jury. No surprise evidence. This is common practice. Nautilus does not oppose it and wants that to be the same for all parties. And that's it for them disputing Cory's motion in limine. Next, we have document 292, and this is Moss and Kuhn's opposition to Nautilus's motion in limine. So one of the big points made by Nautilus was that a valid settlement for Gloria does not exist, that it was fraudulent, and that defendants should be barred from making a claim that it was anything but fraudulent. Moss and Kuhn disagree with this. They state that because Gloria fell on the Murdaugh property, regardless of whether Alex lied about the dogs or not, that Alex was susceptible to a personal injury claim. They say the dog detail only makes that part fraudulent, not the entire claim. That's not the only reason Nautilus claims that this is a fraudulent settlement, but they'll get to the rest of that in a moment. They make a notation to a deposition where this dog claim was discussed. And we find out that Alex wasn't quite as convincing as he thought he was. Now we have Amy Miller here, who was the claims adjuster. And then we have her boss, Catherine. And on page 33 of this deposition, they ask her, "So Catherine, your coverage counsel sends you an email on Friday, March 22nd, saying, 'Worst case of insurance fraud and injustice I've ever heard of.'" And they ask her, "What made you believe that this was insurance fraud?" And she says, "We suspected that the whole story about the dog was not true. Unfortunately, we were never able to prove that. We investigated that issue by getting a hold of vet records, the dog trainer records. We had Mr. Murdaugh saying that Gloria Satterfield told him that. We have Miss Murdaugh, Maggie, who said all of Gloria's relatives were telling her that she tripped over the dog. And then we have Mr. Murdaugh's son, Paul, telling us that he also heard Miss Satterfield say something about the dogs to his dad. We doubted that. We suspected that wasn't what happened, but we never were able to prove that." So Nautilus wasn't buying this story from the very beginning, but there wasn't really much they could do about it. They had Alex as a witness, they had Maggie as a witness, they had Paul as a witness. Alex had even introduced something about training that he'd set up for the dog that he claimed had tripped Gloria. They even went so far to check those records. And again, we don't know if these were friends of Alex that covered for him or if coincidentally the dogs had just been in training. But everything they investigated confirmed Alex's lie. Even though they pretty much knew he was lying, there was nothing they could do to prove that he was lying. Now, what Moss and Kuhn are claiming with all of this is that, hey, Nautilus knew it was fraudulent and they still paid, so the settlement's valid. But I feel like this deposition goes against that, because what the insurance company was saying is not that la-di-da, we know it's fake, but we're paying it anyway. They're saying, we assumed it was fake. We tried to prove it was fake. Our hands were tied. There was nothing we could use to prove it was fake. And now Alex has admitted that it was fake. That means it was fraudulent. And they can say, yes, there would have been a claim anyway because she fell on their property, but it would have been a different claim. And no one can say, under those circumstances, how much that claim would have been. If Gloria had simply slipped and fell of her own accord, there would have been less culpability by the Murdaughs, as long as the stairs were in order and nothing on their property had actually caused the fall. It would have been a different claim entirely. And Alex knew that, and that's why he had to make sure to find a reason that he could take the blame, like this dog story. And of course, Alex doesn't mind at all to throw Maggie and Paul under the bus when they're not alive to defend themselves. With the list of these documents being so long, this has ended up being a little bit longer than anticipated, so I'm going to divide it into 2 parts. So we're going to go ahead and stop here for today and pick up with the rest later.